we've been talking about pre-trial and what all the back room, judges' chambers, things involve. And we've been touching on plea bargaining. And there are some really, really good aspects of plea bargaining. One thing is, especially if the defendant is guilty, he can get a lesser sentence through plea bargaining. And that's good for him. You know, he can get the charges reduced, he can get less sentence, because the prosecution may just be overwhelmed and, you know, they don't want to, they just want to get rid of the case very quickly. They may feel like their case is weak. There's all kinds of reasons that the prosecution may want to plea, and it's beneficial for the defense as well. By pleading, the defendant will know what the status of their case is going to be. They don't have to sit in jail. You know, some of them are sitting in jail because they can't make bond, or bond won't be set, or they're denied bond. And so here, you know, they know what the outcome is. The plea bargaining has been made, and you know, they know it's all closed, and it's closed. They have closure for them as well. One of the things about plea bargaining is the defense and the prosecution can work out this deal, and if the judge doesn't like it, he can throw it out. And it's not done a lot of the times, but he has the right to say, no, you all need to go back and work on this one again. The plea bargaining is very much like a chess game. The defense is doing their strategic moves to try and get the best of the prosecution. The prosecution is making their strategy to try and get the best of the defense. And when I say the best, I'm talking about basically a win. We try to look at plea bargaining as a win-win situation. And plea bargaining is not mandatory that it be offered. It is not offered in every case. Okay, this thing's not going to work. I'm going to have to get maybe one of these. There we go. Some of the things I just mentioned about plea bargaining advantages, it does result in less time for the defendant. It is a conviction for the prosecution, so that goes on their win tablet. It saves time for both the defense and the prosecution and the resources of both. It eases caseloads for both. This way it reduces the trial or the court load as well. And like I've said a couple of times, if the case is weak and the prosecution is not real confident they're going to get a win, at least some justice is served as opposed to the person getting off completely. Did you have a question? No. Okay. Oh, come on. Plea bargaining is not accomplished normally in one meeting. It's a give and take. They offer, it's rejected, the counter offer is rejected, and then they come up with a mutually agreeable decision there. A lot of times a good buddy system is used, you know, and the prosecution normally goes in with a good position at first, because the defense doesn't know all of what they've got in their hand. And the defense is in a good position especially if the prosecution doesn't want to fool with the case. So, you know, the time taken in plea bargaining can help both sides. If they decide not to plea bargain while they are talking, the new evidence may come out, or that in discovery during the talks, that the defendants will learn more about what the prosecution has. I've touched on this before. When the prosecution decides that they're going to take a case to court or to trial, they have the opportunity to either go for the best charge or use a shotgun or scattergun approach and hit them with everything they've got, and sometimes try and scare them into a plea bargain. Sometimes a plea bargain is offered so that they'll give up somebody else or give up some information. And okay, if you'll tell us this, we'll offer you this. You know, like if you'll testify against this person, instead of going for the death penalty, we'll offer you life. You know, the defense has a right to ask for a jury trial. The defense makes pre-trial motions, and he also has the right to ask for rescheduling. Now, let me tell you all a secret about something. Now, let's say that you get a speeding ticket, okay? You have the right to ask for it to be rescheduled. The trial, you can call in and say, well, you know, I've got to be out of town, I've been called for such and such. And if you do that a couple of times, the cop that has to testify will more than likely not show up for the hearing, and if he's not there, the ticket's thrown out. And so if you can get the thing rescheduled several times, there's a pretty good chance that you might get that ticket thrown out. Little bit of information that you get from criminal justice that hopefully is beneficial. Boykin versus Alabama, this is where SCOTUS ruled that before a judge can accept a plea, the defendant has to be asked, does he understand what the plea is? Do you understand that, you know, what you're agreeing to? Was it voluntary? Okay, were you coerced in any way? The trial judge also asks, do you understand the consequences of this plea? Okay, you have agreed to life in prison for this charge. You can't appeal it now. When you agree to this, this is the sentence. Okay, so the trial judge asks, does the defendant understand the consequences? Was this plea agreed to by the defendant voluntarily? Do you understand it all? Again, he's also asked if he was coerced, if he was forced, if he was pressured into taking this plea. Now, I don't know if y'all know, but if, say, the prosecution offers a plea, the defense is required to take that to the defendant, even if he doesn't think it's a good deal. And he can tell the defendant he doesn't think it's a good deal, but he can't just make that judgment and say, well, I'm not even going to bother him with it. He is required by law to inform him of that. When you take a plea, you give up some of your constitutional rights, such as right to trial by jury. Another thing is, a lot of times, society will think that they didn't get the justice that they needed. Okay, so this guy beat up a woman and raped her, and it's pled out for assault and endangerment or something, okay? Society can get really pissed off about that, and they'll say, well, it's just not fair that that guy got off when he raped her, and all he's getting is assault and, you know, disorderly conduct or whatever. Pleas are hidden from judicial scrutiny. It can be unfair to those who reject the plea and get a greater sentence. And so this defendant is offered a plea, and he says, is told, okay, if you are found guilty, you know, the judge has a lot of leeway. He can give you life. He can give you life and without parole. He can give you the death penalty. And then when they get convicted and the judge goes for the maximum, then there's people that say, well, it wasn't fair because the judge and them are just mad because he didn't take the plea and given him the worst. Remember in Justice for All how the guy with the broken tail light pled guilty to one of the charges, and it ended up that he just kept on getting more and more in trouble with the system? Sometimes a person who's innocent will plead guilty because they are scared, they don't have confidence in the system, they don't have confidence in their lawyer. Their lawyer will say, you know, I know you're innocent, you know you're innocent, we can't prove it, and they've got circumstantial evidence all over the place. And so even though the guy's innocent, he pleads guilty, and that is not justice. You know, one of the things of this system is it's supposed to be justice. And we're losing sight of justice to try and get more and more in the win columns, and that's not right. So far, a guy's committed a crime. The police have investigated it. They've come up with the suspect. They've come up with evidence to validate their belief this person did it. They get a warrant and they arrest him. All right? He's booked. He has an initial appearance within 48 hours of the trial, and then he goes to trial. Okay? The slide says one of the most important factors on whether or not the person's going to be tried is how serious the charge is. Also, how much public interest is in it. That's going to be a main factor as well. Fewer than 9% of felony cases go to trial. What that means is there's a tremendous amount of plea bargaining and a tremendous amount of drop charges. Why do y'all think there's only 9% that go to trial?
9% believe that they're innocent.
Do what?
That 9% believe that they're innocent.
I imagine all 9 of those believe it, but there's probably a bunch of the others that believe that they are innocent too, but they want to avoid trial.
Would it be because of corruption?
Okay, you're right. All of these things are right. They believe that they're innocent. They want their trial by jury. They want their day in court. but also, when you're looking at 9% of the felony cases go to trial, I wonder how many of those the prosecution says, yes, this is a slam dunk, we'll take it to trial. And that's what's sad, okay? I don't wanna take this to trial, and in fact, Mike used to work in the, child pornography unit at the Attorney General's office. He had a slam dunk case, had a file tremendously thick, had all the evidence, had everything they needed to absolutely nail this guy. And the prosecutor wouldn't give him the warrant because he said, I just want a little bit more on him. The guy got wind of it, left the state. And they couldn't get him in. You know, he wanted to make sure he had that, you know, slam dunk. And the prosecutor didn't have enough confidence in himself and his investigators. And they had an absolute slam dunk case, and the prosecutor let it slide through his fingers. Okay, bench trials. You have the right to ask for either a jury trial or a bench trial. If you go for a bench trial, there is no jury. The judge listens to both sides, and then he makes the decision. Guilty or not guilty, and then the sentence. Okay? There's really some decision making that goes into whether a bench trial or a jury trial. If the defense thinks that they've got some emotional issues that can sway the jury, they'll probably go for the jury trial. But if they know that they've got absolute legal precedent and that, you know, the cases, the legal cases and such prove their case, and the judge will be listening to the facts, they may go with the bench trial. What's a jury? Well, normally it's 12 people that's selected to listen to a case and determine, after hearing all the facts, whether or not a person's guilty or not. Okay? There are some states that only require 6 on the jury. But if they have 6, all 6 have to be absolutely unanimous in their decision. There are some cases that the 12 can just have a majority, and that's all it takes. There are some that they have to have a unanimous vote. But the jury, as your thing says, is a panel of citizens selected according to law and sworn to determine matters of fact in a criminal case and to deliver a verdict of guilty or not guilty. Normally, you're going to be chosen to be on in a jury pool by voter registration. Now, I'm not sure, I heard somewhere that Arkansas also includes driver's licenses, but I can't vouch for that. You have a right to a jury of your peers, and to me, that's going to be a little hard to completely get a jury of your peers, but they do their best to try and get a cross section. I was telling you about the 6 that was decided in Williams versus Florida, that they could have a jury of 6. Birch versus Louisiana, smaller juries must vote unanimously. Now, when you are in a jury pool, first of all, you'll get a little card that says you have been chosen to serve for the next 6 months as a jurist. Now, the way we do it in Arkansas, you get that card, and then they say you have to show up at such and such a date for orientation. You go in, and depending on the judge, that's how long it's going to take. Now, there's one that the bailiff, while the judge is out of the room, he's going to say, look, this judge is really long-winded, and he loves to give this particular speech. He said, just hang in there and just grit your teeth, because he's going to do it, you know. I've been in jury pools where the judge just said, thank you very much for coming, we do appreciate it, gave a very quick orientation of what was going to happen, thanked us again, and left. The other one went into the history of the judicial system, how being a jurist is not only an honor, but it's a privilege that the judicial system couldn't exist without jurists and such. And it was a long presentation, just like the bailiff said. Then what they do in Arkansas is they have different people assigned for different days. And so you might have 30 or 40 people assigned for Tuesday court cases. You have another jury pool assigned for Wednesday court cases. Another one for Thursdays. I don't think they have them on Fridays. The day before your court case, or the day before the day you're assigned, you call and say, okay, are there any court cases tomorrow scheduled? And they'll say, nope, you don't have anything scheduled, so you can go on with your life. But they might say, there is, in fact it's a recording, they'll say, there is a trial scheduled tomorrow, there is a trial, be here at 8 o'clock in the morning, room such and such. And so you meet in that room, in the courtroom, and there'll be like 30 people there, and the judge will come in, everybody stands up, and then he introduces himself, the prosecution introduces themselves, the defense introduces theirself, and they put everybody's name into like a big fishbowl, and they'll draw out 15, maybe 20 names. All right? Those names that were not drawn are immediately excused. So, then they'll start calling the names, and the attorneys will question you. And they'll say, you know, like, there was one time I got excused because of the questioning. It was pretty cool. I was, what's your name? And I told them, where do you live? I told them, are you a resident of Pulaski County? Yes, I am. Well, the prosecution says, wait a minute, before that, before I was called, before that happened, I wasn't called, the prosecution said, is there anybody here that's a teacher? Okay, so I raised my hand, and they said, where are you a teacher? And I said, I'm a faculty member at Pulaski Tech College. What do you teach? At that time, I was just teaching psychology. I said, psychology, okay. If we had a case that involved a teacher, do you think that you could be unbiased? And I said, yes, I think I can. Okay, thank you. Then they asked some more questions. Then they said, is there anybody here that is a therapist? And I raised my hand, and he said, you're a therapist? And I said, I'm a licensed professional counselor and a licensed marriage and family therapist. Okay. Do you know these people? I said, no, I do not. Have you ever counseled with these people? No, I have not. Do you have any knowledge of this person's of this person at all, or possibly a therapist that is working with that person. I said, I don't know, I've never heard anything about this. Okay. So, they let some more people go because of biases and such. And so then, the thing had whittled down some more, and they said, is there anybody here that's associated with law enforcement? Raised my hand, they said, you're associated with law enforcement? I said, yes, I am. Well, how are you associated? I said, well, I'm a deputy with the Pulaski County Sheriff's Office. Do you think that every police officer is honest? And I said, well, I can't answer that, but I can tell you this, every police officer I know is honest. And the guy said, Judge, can we just go ahead and release this one? Excuse her. And he said, yeah. And so I've got excused because I think they thought if they asked any more questions, I was going to pop my hand up. But that's the way that one went. I got chosen for a jury that was hearing an insurance case, and we had gone 2 days, and the person next to me was making all kinds of little mumbles and statements and stuff while the case was going on, and like the defense would say something, the prosecution would say something, and try to make a point, and the person next to me go like that, and just really being obnoxious. And I guess they got too loud because after lunch, we came in and they said because of a jurist's bias, we're having to declare a mistrial. And we've heard the statements that's being made, we've heard the reactions. We think that this could taint the jury pool. And so they called a mistrial. And so, that was my experiences with being a jurist. The jury listens to the facts. Prosecution, well, they'll give their side, then the defense gives their side, then the prosecution gets to bring in any kind of witnesses or something to rebut or rebut some of the things that the defense said. The defense gets to make a statement after that, then it goes into the jury. The judge is a referee. One of his chores is to make sure that the jury remains impartial. That's like that when I was on the jury, and that they, and I mean, she was just really obnoxious, It says here that there are 6 vital functions in the criminal justice system: to prevent government oppression by safeguarding citizens against arbitrary law enforcement, to determine whether the accused is guilty, to represent diverse community interests, to serve as a buffer between the accused and the accuser, to promote citizens' knowledge about the criminal justice system through the jury duty process, and to symbolize the rule of law. So now we're moving into trial. The jury is selected. Each side gives opening statements. The prosecution gives their opening statement and the defense gives theirs. It's a summary of their case. This is what you can expect to see over the next couple of days. This is, our person is, that person is innocent, that person is guilty, we're going to prove it, okay? The prosecution then produces their case, which is evidence and witnesses. The defense gives evidence and witnesses to convince the jury that the prosecution has not met the burden of proof. The burden of proof has to be that the jury believes beyond a reasonable doubt of a reasonable person that this person committed the crime. After the cases are given, then we have the rebuttal witnesses. Then the defense gives their slant, they can go ahead and interview that rebuttal witness. Then there's closing arguments. Then the judge gives instructions to the jury. The jury then goes into the jury room. Normally, the first thing that's done is a jury, I can't think of the word, but it's the person that is in charge of the jury. They're selected. They kind of take over, okay, what do y'all think about this, and organizes things. Then they start taking votes. If it's a slam dunk right then they get to go back and say, we've got a decision. But let's say that it has to be a unanimous decision, and you've got a 11-1. Then the jury has to talk among themselves and, okay, why is it you think this guy's innocent? Well, because such and such and such and such. And they'll go back and forth, and if that one person does not change his vote, if it's required to be unanimous, and they're there for a week, 2 weeks, 3 weeks, then they can say, Judge, we are just hopelessly hung. And there'll be a mistrial documented and declared. And the prosecution then has to decide, are we going to do all of this over again? And if they decide not to, then the case is dropped. Okay, we talked about that. I did not mention this. Since the advent of these forensic science shows on TV, it's making it very, very hard for the prosecution. The juries now are expecting, when they go in, to have a forensic case presented. We've got this much DNA, we've got this much trace evidence, and we've got beyond, we've put such and such into the glue machine, and it lifted prints from a leather coat, they see all these things on CSI and NCIS and such, and states like Arkansas doesn't have all that. We've got a good lab, but we are understaffed, and we don't have the kind of lab that they have on TV. And so there have been several very famous cases that in the past would have been enough with what they went to trial with, but because they didn't have all the CSI evidence, the jury found that there wasn't enough evidence to convict. And so it's getting difficult, and that makes it harder for the prosecution, it makes it harder for the cops, because they have to come up with more evidence and more solid evidence than they used to have to. The burden of proof is on the prosecution. Theoretically, the prosecution could give an entire case, and then the defense get up and say, we rest, and not say a word. And the question is, did the prosecution give enough evidence to convict this person? To go beyond a reasonable doubt of a reasonable person to say this person is guilty. The defense is not required to present a case. It's the prosecution that has to prove that person was guilty. Okay, we've got real evidence that's presented, and that's physical evidence like weapons, records, fingerprints, property that's recovered. Then you've got demonstrative evidence. This is evidence that is not based on witness testimony, but it's relevant to the crime. That would be things such as x-rays, photographs. My partner at Saline County, when he goes to a crime scene, it is not unusual for him to take 200 plus photos of a crime scene. When Mike has one, like he was telling you, the worst that he's seen, 200 would be a very minimum. You know, they get everything they possibly can so that they have everything documented. Then you've got your testimony, that's your oral evidence, and that's your witnesses and such. Then you've got direct evidence, that's your eyewitness accounts. And then there's circumstantial evidence. And that is where a witness says they saw something, but they didn't see a direct crime, so the jury has to infer that what they saw was implicated in the crime, such as they're in their apartment and they hear a shotgun blast, and they look out the window and they see a guy running from a car with a shotgun. Well, they didn't see him pull the trigger, but they saw him running from the car with a shotgun. So they have, they can infer that this guy shot this person with a shotgun, even though the witness didn't directly see it. That's circumstantial evidence. Okay. The defense tries to present evidence to disprove the prosecution. They are not required to present anything, but they try to introduce contrary evidence to rebut the state's case. They try and establish an alibi. They will present an affirmative case, and they assure that the defendant's constitutional rights are preserved and maintained, including the Fifth Amendment. And that means that the person does not have to testify against himself, and the jury, I believe, is instructed that if they don't testify themselves, they cannot infer that they're guilty just because they don't want to say anything. The prosecutor may not comment, nor can the jury draw inferences from the defendant's decision not to appear in his own defense. Cross-examination, when you have a witness give a testimony, the opposite side can try and impugn that testimony by asking questions and tripping them up. It can be broader than direct examination. Direct examination has some very, very narrow laws on what they can ask. Now, the judge might say, okay, here's a great example. The judge says, okay, officer, in the chambers, officer, you cannot to the prosecutor, to the officer, you cannot ask about the defendant's record, legal record and jail record. We're throwing that out. You cannot ask that. Okay. So, the prosecutor doesn't ask anything about the defendant's prior history with the legal system. All right, so the defense attorney gets up and he says, well, you saw this this person how far away? And he says, well, probably about 100 feet away. And 100 feet away, you say you recognize this guy. Yes, sir, I did. Well, how did you recognize him? from the 3 times that I arrested him before. Because the defense opened the door, he could say that. But the prosecution couldn't say, does he have a legal history? See, because that would be a direct question. But when the defense opens the door like that, then the officer would be allowed to make that kind of a statement.
Just opened the door, he blew it wide open.
Absolutely, absolutely. The prosecutor may not only ask about the crime, the witness past the past criminal convictions. Okay, so that's what we just talked about. Okay, we've already talked about rebuttal, closing arguments. Each side will review the case. They will say, you know, the prosecution is going to go heavy on the facts and heavy on emotion. Okay? How would you like to come in and find your grandfather in the floor where not once, not twice, but 5 times somebody hit him and hit him and hit him and hit him and hit him again with a hammer, and then they stabbed him? How would you feel if that was your grandfather? How, you know, he was a respected man in the neighborhood, in the community. People loved him. And somebody, you know, stabbed him. Not only did they hit him 5 times with a hammer, but then they stabbed him another 10 times. He looked like a hamburger when he was found. Okay? Now, that's something that it would be very likely that the prosecutor would say, because he wants to introduce, rehash the facts and add emotion to it. Get to the jury's hearts. The defense, they're going to set forth all the laws that can apply against this case. They're going to try and show reasonable doubt, okay? And they are going to try to prove that the prosecution didn't make the case. They do that in reviewing the case and trying to hammer on the points that are the weakest parts of the prosecution. Then the judge gives instructions to the jury. He says that you have to decide on legal principles, not emotions. One of the things that they have to base their decision on is reasonable doubt. The juror must be satisfied to a moral certainty rather than wavering or uncertain. Realistically, juries don't understand most of the instructions. And you get one of these judges that are verbose, and he goes on and on and on. He's going to lose the jury right there. The decision, if it becomes a very controversial case, or if the judge thinks that when they go home that they're talking about the case, or they're seeing things on TV and such, he can do what's called sequestering. And that's where he brings them all together, and they have to stay all together on basically one floor of a hotel. They bring in the meals at night. There's no TVs in the room, and they're not allowed to talk with each other. They're not allowed to have a phone, and they have to stay that way until the jury's over, until the trial is over. And we've already talked about deadlocking. So, the person's arrested, booked, has an initial appearance, the trial, the appeal, and then he's convicted. So, the next thing is the appeal. And they cannot retry the case in front of the appellate court. They can only take points of law that they think was violated and get the appeal through a violation of a person's rights. Typically, the defendant has a right to appeal the verdict to a higher court. It's based on a claim that one or more errors of law or procedure were made during the investigation, arrest, or trial. It's a question of procedure, not guilt, not innocence. It's whether their rights were violated, that there were some kind of procedural violation, or that there was some kind of error in judicial ruling. Okay, habeas corpus. A judicial order requesting that a judge examine whether an individual is properly detained in jail, prison, or mental hospital. Let's say that there was a murder and a person goes before the initial judge, and the judge says, okay, I'm keeping you in jail. Well, the lawyer can go and file what's called habeas corpus, and that then they have a ruling on whether this person is a threat to the community, a threat to themselves. Are they properly being detained in jail, or is it outrageous? Only 1% will succeed, and that last one I'm going to have to check on because I don't know what that means. Oh, that's the end of the chapter. Oh, and that's the end of the class. Any questions? I'll try and find out an answer to that last thing.